factual or legal grounds which currently disqualifies Judy Stearns from taking the oath of office for alderman for the 4th Ward. And I'll give you my reasoning. 2 weeks ago, I became aware of what we've now all known as the Jackson case. The Jackson case involved an issue which, in identical terms, can be faced by a city council, although it's in 2 different points in time. In the Jackson case, a candidate for the City Council of Chicago had filed nomination papers. Shortly thereafter, someone filed an objection to that person's candidacy on the grounds that the candidate had multiple homestead exemptions in the city. And because of the undervaluation of the property taxes, according to this objector's opinion, that person was therefore in arrears to the City of Chicago on property taxes. Although the hearing officer and the Chicago Board of Elections and the trial court agreed that the candidate didn't have an arrearage, the appellate court surprised, I think, a lot of people by determining that the multiple homestead exemptions did cause an undervaluation in the payment of property taxes, which did cause an arrears in taxes to be owing to the City of Chicago. Now, I'm going to use the word snapshots a couple of times because there are 2 dates when snapshots are very important on arrears. One of them is the date a person files their papers for nomination. You can't undo that once the papers are filed. In the Jackson case, the court said, in accordance with prior case law, that since she wasn't eligible to be an alderman on the date she filed her nomination papers by reason of the tax arrearage, she wasn't eligible to be on the ballot and her name had to be stricken. The other snapshot that's important is whether a person is indebted to a city in taxes or other indebts on the date of an oath of office, and that is where the City Council has the authority to determine that person's eligibility for office. I contacted the mayor as soon as I found out about the Jackson case. He and I both agreed that evening that it was fair to talk to Judy about this and to give her a heads up on it. She was very cooperative. Mike Ireland and Judy and myself worked to try to calculate any arrears based on the logic of the Jackson case. And we have, to the best of our ability, Mr. Ireland and I and Judy calculated those amounts, and she has paid those amounts. The other issue is the council is also given the authority to act as the judge of elections. However, in every case I found where a city council has done so, they have used the same statutory guidelines as a court would if a challenge were filed after an election, which is, was there some error or fraud in the way the votes were counted, or was there some irregularity in a particular precinct in the way that election was conducted? I haven't found any situation in which a city council tried to go beyond those particular issues in the statute where you were given the ability to be the judge of an election, where the council's decision was upheld. And specifically, because I thought this would be quite important, I have not found any cases where a city council was able to successfully keep someone from assuming office on the grounds that even though their name was on the ballot and they won more votes than anybody else, that their name shouldn't have been on the ballot and therefore they shouldn't be allowed to take the oath of office. So those are the 2 factual and legal issues which you would have the ability to address tonight. I've given you my opinion that as near as any of us can calculate, there is currently no tax arrearage or indebtedness on the part of Judy Stearns. Nor am I aware of anything which indicates any irregularity in the way the votes were counted or the way the election was conducted in any of the precincts of the 4th Ward a month ago. So that's, given the 5 minutes, that's what I have to say. In case there are any questions, I can answer them.
We can use the remaining time in the 5 minutes to ask questions right now, but I think we will hold our other questions at the end of the 5 minutes.
Make sure something silly didn't happen. So there was a time when I was a regular attendee here. Anytime I've been here, it's always been for real estate development, and as you all know, that's a little bit slow. Mr. Mayor, I can't possibly do it in 5 minutes, but I'll rush through this. I need to tell you that on no less than 9 occasions have I asked to know what the procedure was this evening, and I request on 5 written occasions that I meet to discuss this with you and with the city manager and with Todd, so I know what the procedure is. Giving me 5 minutes to do this is insufficient. I'll do the best I can, and I believe I'll be going over 5 minutes, and to the extent I do, let me apologize in advance. Mr. Mayor, you're dead wrong in your explanation of the Jackson case. I didn't have the, I know you've got a very fine education. I didn't have the privilege of some private schooling. I'm just a state school graduate. But both you and Todd Greenberg have skimmed over the fact that Cook County, during the relevant time, had issued a billing to that candidate related to trying to collect the tax due to the error of the multiple homestead exemptions. That is the controlling fact, and that controls a proper legal decision as it pertains to Judy Stearns. It is undisputed, and I'm confused as to why it is that I have to be saying this, because it's been well known by the city for a number of days, but it's undisputed that the supervisor of assessments of McLean County has no interest in attempting to have ever collected anything from anybody in the history of the county as it relates to errors that occur for homestead exemptions. They have much bigger issues to contend with, and our supervisor of assessments is an extraordinary public servant who creates millions of dollars of tax revenue for the taxing bodies that levy under our real estate tax bills. There is one event in particular which distinguishes him from assessors in the entire state of Illinois, and that is when he implemented the instant assessment of new properties. And he creates taxes for periods of time by implementing instant assessment that would be lost permanently. And this has created millions and millions of dollars of tax revenue for all the taxing bodies that participate in our tax bills. I would encourage you to allow him to continue that fine service and to not suggest that he get bogged down in looking at every owner-occupied premises and all the new owner-occupied premises and all the premises on farms that are owner-occupied, and keep track of obituaries and everything that would be required in order to determine whether owner occupancy is appropriate on every property in McLean County. The law is very clear, and it is stated in the first exhibit that I have given you, the very first tab, and I have highlighted it, that the assessor, the supervisor of assessments, has the complete jurisdiction to issue the general homestead exemption. His decision is not subject to appeal. It can't go to the Illinois Property Tax Appeal Board. It can't go to court. He has the total authority to do it. There is no written form that exists to apply for it. Again, in the law, in that first tab, it says the assessor can use a number of different ways to determine whether or not it's proper. Practically any way, including personally inspecting the property. In McLean County, if you go into the supervisor of assessment's office and ask for a form for the homestead exemption, they're going to tell you there isn't one. If you're entitled to one, ask for it. And if they find out you're not entitled, they will immediately eliminate it. And if they issue one in error, it'll stay there until somebody points out that it is inappropriate. And as soon as they find out it's inappropriate, they will eliminate it. The assessor's office stands tall, and the assessment team that consists of the city assessors and all the rural township assessors and the great people in the supervisor of assessment's office are very fierce in upholding our taxing system and making it fair and equitable for all parties. As a result,
Sir, you're at your 5 minutes. You need to be far more concise and try to sum up. I'll give you a few extra seconds here.
let me say that none of the assessments that Judy Stearns had were the result of any requests that she made or anything that she did to encourage them, other than she asked that there be one on the apartment that she lived in, and she asked that it get transferred. It got transferred, and the one that existed on the original apartment she lived in was not eliminated. Clearly, in this case, the existence of the assessments were the result of assessor error, and I think it's an abuse of judgment on your part to try to make a claim out of an assessor error into an election error. Let me also indicate that
10 seconds.
that I have read the city code, and on May 1st, Judy became the elected representative based on the last election. I've attached it in this packet. Your code provides that on May 1st, she took office. It also provides that the oath is administered by her signing it under oath. Thank you.
Thank you. I apologize on the limitation, but we do have need some time for discussion here, and there may be an opportunity to add